What's up, everybody? This is attorney Dan Nguyen, Dan Nguyen again. Let me say my last name. But I want to talk to you a little bit about LLCs and splitting different ownership and profit and loss allocations. Now, this is kind of a more advanced topic, but it comes in handy when you have, obviously, when you have more than one owner. And in a traditional case, if there's more than one owner, let's just say two, and if one person puts in $75,000 and one person puts in $25,000 cash, then the one person would have 75% of the company and the other person would have 25% of the company. But sometimes there are situations where you might want to change this and not adhere to the default rule where the amount of contribution equals the profit and loss distribution. Now, it's possible that you can have different profit and loss allocations allocated to the owner. So in this is a scenario where someone put in 75%, another person 25%. You don't have to do it that way, as long as everyone agrees in the operating agreement that maybe one party gets 25% profits and losses, other person gets 75% profits and losses. I don't know why they would want to do it this way, but technically they could do it. Now, it's really important that it's written down in the operating agreement. You don't want this to be a handshake agreement. You don't want this to be some backdoor agreement. You want this written down that all parties understand that who the ownership structure is, who the ownership percentages are, and what the profit and loss allocation is. Now, here are a couple of reasons why you might want to do it outside of the default rule. One, sometimes there are parties, members or owners putting up not cash, but maybe sweat equity, right? Maybe they're actually doing all the work, and another party is just putting up the startup capital. And maybe the person that wants to that is doing all the work wants to get more of the company, maybe 51%. So in those particular situations, that might be a particular reason. Another situation is maybe one of the owners is using this as a loss to offset some income from their other businesses. And I've seen this before, is one party owns, let's just say 75% of the profits and losses, but they are a minority shareholder. Let's just say they own 25%, right? But what they can't do is now if the company's taken a loss, which is pretty common in the first couple of years, then they can carry those losses against their other income and offset some of the income from their other businesses. So this all is just to say the default rule is in proportion to their ownership as to allocation of profits and losses, but the parties can agree that it can be distributed differently. So this is Dan talking about LLCs, structuring them differently according to the ownership and profits and losses. And if you have any questions, feel free to reach out to us. Let's do a consultation and we can help you out. All right, this is Dan. Talk to you soon. Bye.